On Thursday morning, when the Supreme Court handed down its momentous decision in National Federation of Independent Business versus Sebelius, that would be the actual name of the healthcare case, it was once again playing a unique role in the evolution of this great project started back in 1776. You see, the court is never an agent of change. It has no constitutional authority to actively pursue any matter. The court is essentially passive, awaiting issues large and small to be presented. Its role is not to be the agent, but rather the final arbiter. And what we saw on Thursday was what history ultimately will recall as another moment in an essential timeline determining the course of a nation. We go back to the 19th century when a slave named Dred Scott sued for his freedom. In 1857, Chief Justice Roger Taney's Supreme Court ruled Dred Scott was not entitled to due process because people of African ancestry were not citizens. Almost 50 years later, black Americans, now citizens, faced a new challenge as Jim Crow descended. In 1896, Plessy v. Ferguson, the Supreme Court, led by Melville Fuller, decided that separate but equal was the law of the land, giving Southern states and private companies free rein to discriminate and to separate. The misguided practice continued for decades until a social movement brought the challenge before the court again. It was in 1954 that Chief Justice Earl Warren's court reversed Plessy and found in Brown versus Board of Education that separate is, in fact, inherently unequal, forcing school integration with all deliberate speed. We cannot forget Chief Justice Warren Burger's court in 1973's Roe v. Wade decision. That court made clear that a woman does have a constitutional right to privacy. These decisions serve as markers in our nation's progress in both their determinations and, at times, their indelible rhetoric. Court rulings become the telling points of our history. There may be little literary flair when Chief Justice Roberts wrote in Thursday's decision, quote, "The Constitution permits such attacks, and it is not our role to forbid it or to pass upon its wisdom or fairness." No literary flair, but the decision itself will reverberate in history. Change has come to America, and the nation's final arbiter has said it is so. Up next, that 1973 Roe v. Wade decision I mentioned, that paved the way for another decision, one that many women make every day: how to balance work and motherhood, whether to strive to be supermom. I'll tackle that after the break.